But here, so far as entry 8 is concerned, the Constituent Assembly debates does not throw much light. But I want to show, my lord, those 4 stages again here also to show how this was clubbed, with what products it was clubbed. But at the foot, Government of India Act 1935, Lord, I have shown the devolution rules had both the entries, taxing and regular entry. Intoxicating liquors and narcotic drugs. That is to say, the production, manufacture, possession, transport, purchase, and sale of intoxicating liquors, opium, and other narcotic drugs, but subject as respects opium to the provisions of List 1 and as respects poisons and dangerous drugs to the provisions of List 3. But then draft of by the drafting committee. Intoxicating liquor and narcotic drugs. Well, substantially the same. Your lordships may consider avoiding that, ignoring that. Now kindly see, my lord, draft entry 40 was placed before the Constituent Assembly. There is a short debate on the same on 2nd September 49. It may, however, be pointed out that the debate dated 2nd September, on which entry 8 list 2 came to be finalized, had a tremendous impact of the earlier debate dated 19th, 23rd, 24th November 48, while introducing Article 47 as one of the directive principles of state policy. The debate which took place regarding draft entry 40, list 2, that is present entry 8, is as under. My lord, your lordships can skip. Nothing much will assist your lordships, my lord. Now, Lord, kindly directly come to page 31. Lord, there is the very extensive debate preceding Article 47, Directive Principles of State Policy. Lord, one of the honorable members on the lighter side, and he says this. He said that I have never spoken in my life. I never used to participate even in debate competitions. In this Constituent Assembly debate also, I am speaking for the first time. But I feel so strongly that I want to speak. So there is a detailed debate which I have not quoted. I have annexed so that your lordships can get the immediate reference. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of level of nutrition and standard of living of its people and improvement of public health as amongst its primary duties, and in particular, state shall endeavor to bring about prohibition of consumption except for medicinal purposes of intoxicating drinks and drugs which are injurious to health. The Honorable Court would notice, and your ladyship remarked, that here the word used is intoxicating drink, because the Parliament wanted to give a little expansive meaning, because apart from intoxicating liquor, there are drinks like bhang, etc. Therefore, my lord, it's an expansive meaning. Now, my lord, this is considered in one judgment where your lordship's court, my lord, quotes Sirvai. Please see, my lord. The importance of Article 47, this is Ashok Lanka versus Rishi Dikshit. The importance of Article 47 of the Constitution may have to be noticed, tracing the history back from the date of constitutional debate. With a view to find out the intent and purpose for which the said provision was inserted, Sri So-and-so noticed that all sections of the society, including Mohammedan community, whose social habits were reinforced by the Quranic injunction in relation to intoxicating liquor, supported the insertion of such a provision. Consumption of intoxicating liquor in Quranic culture can never mean non-potable. It has to be potable liquor. The prohibition of intoxicating liquor had long been a part of the policy of Indian National Congress. Congress would never have a policy for non-potable industrial alcohol. And its inclusion in Article 47 received support from the Mohammedan community whose social habits were reinforced by the Quranic injunction against intoxicating liquor. In considering the directive in Article 47, it may be observed that the alcohol, the intoxicating ingredient of liquor, is a narcotic, a word replaced by the word depressant to describe the same effects, contrary to the popular belief that it is a stimulant. It is not mere accident that intoxicating liquor and dangerous drugs have been clubbed together in entry 8, list 2. This is, my lord, commentary of Honorable Sirvai, my lords. Lord, please come to, my lord, now the main question, my lord. Why there are two different expressions used. Lord, I'll read 3 or 4 paragraphs, but my lord, just let me paraphrase my submission. So far as entry 8, list 2 is concerned, my lord, prima facie, textually, contextually, it means, my lord, a beverage which can be consumed, which has the effect of intoxication. The Parliament is not concerned with the intoxicating effect which the person will have or will not have, or it is alcoholic, etc., etc. Therefore, with a view to ensure that the legislature providing for the taxation of non-potable liquor can decide the incident of tax. But it is not saying intoxicating liquor. But kindly in this context, please see para 32, para 35 and page 32. That's the only distinction, my lord, which we can get. These words, expressions.
If you look at it, in support of what you are saying, which is that alcoholic liquor for human consumption is a species of intoxicating liquor. Right? So, intoxicating liquor will include a variety of products, a variety of products, I'll say, of goods, including alcoholic liquor for human consumption. When the legislature imposes a tax, it has to impose a tax with clarity. Therefore, they identified the product itself, namely alcoholic liquor for human consumption. When it comes to the regulatory power of the state, that regulatory power of the state under entry 8 is couched in much wider terms than the taxing power, for the reason that when you regulate both what is legal and what is illegal. So, the idea of conferring the power on the states to regulate intoxicating liquor was to allow them to also deal with
after effects, social effects, etc.
And where the intoxication may not be due to alcohol, but non-alcoholic intoxication also in that liquor. So, the alcoholic content of the liquor may be one source of intoxication. But to give regulatory, suppose they were to use the expression instead of intoxicating liquor in entry 8, suppose they were to use the expression alcoholic liquor, the states would not have the power to deal then on a regulatory basis with other things which are not exactly, which are not alcoholic, but which are intoxicating nonetheless. Okay. So the regulatory domain of the states was widened as compared to the taxing domain, because the taxing domain has to be always extremely specific, because you have to specify what is the taxing event.
I'm grateful, my lord, that I could not have put it, my lord, that more succinctly than that. For example, my lord, for regulating the consumption liquor, the liquor which is meant for being consumed, the state may need several regulations. Don't drink in public in some circumstances. Don't do certain things, etc., etc. And we trace the history in Britain, because ultimately a 1919 Act, 1935 Act had an impact. We were a British colony. And even in the Constitution, so far as some expressions are concerned, it has the British imprint.
More laws are not.
अभी आता है.
Liquor is much wider than alcoholic liquor.
Yes.
That's
That is
that's
one.
what you are driving at.
Yes, bro. Number two, while providing for a taxing entry, the taxing statute will have to define the incident of tax. For example, excise when the liquor is manufactured. Which liquor? Liquor which is ultimately going to be used for human consumption. For example, under entry 52 list 2, taxing power of the state, same expression. Alcohol, liquor for human consumption.
So it specifies the taxing event.
Taxing event.
It is alcohol,
Incident
but
of.
it is defined with the reference to the purpose.
Yes, purpose, and it necessarily involves human being, because the word intoxicating means someone is getting intoxicated. Here for the taxation purpose, it's not necessary. You manufacture alcohol, whether it is potable or non-potable, the taxing event takes place. Whether it may be consumed, may not be consumed, it may have X intoxicating effect, Y toxicating effect, the taxing statute is not concerned. Therefore, it is only in the taxing entries that the word alcohol for human consumption is used. That I am manufacturing, I am liable to excise. I am selling at this point of time when the sale, your lordship knows about several judgments, whether sale takes place at the time when the contract is entered into, or when the delivery is done, or when sale is complete. That's a matter of separate argument in taxation. But then for defining incident of tax, they put it in a general way that whenever you produce alcohol for human consumption, this is the incident of tax.
That is the end use of that product.
Is
Is
it
the basis.
if it is to be regulated other than tax, fiscal regulation, then entry 8 list 2,
But for taxation, it is the end use of that product
which is relevant. Yes.
which is relevant.
Yes, it's yes. But at what point of time it becomes taxable, That is entry 86 and 52 respectively of list 1 and list 2.
But, just as Brother Oak said, intoxicating liquor is wider than alcohol for human consumption. But according to you, even in the intoxicating liquor, it has to be something which is intoxicating to a human being.
Yes, has to be, my lords. Because the word intoxic, otherwise it loses its meaning.
That's right.
Not necessarily alcohol. For instance, you have all these classical cases on somebody being inebriated with the distilled essence of mahua flowers,
Yes.
right? In law college, they taught that case to us when somebody was, but so that is not alcohol. I'm not conversant with it. I may be wrong.
My lord, mahua
Not
is
sure-
the raw material for an alcohol.
But mahua flowers per
In
se is not
Gujarat, my
alcohol.
lord, it is quite.
But you can still regulate it as can you regulate it as intoxicating
Yes,
liquor?
mahua, yes. Mahua, yes. No, not mahua flower per se, but the mahua alcohol, mahua liquor. It is, mahua is converted into liquor.
Into alcohol.
Supposed to be stronger than the regular liquor, my lord.
So what are those intoxicating substances
Bhang,
which may
my
not
lord,
be
for example.
alcohol?
Bhang, my lord, for example.
Bhang does not contain alcohol. Bhang does not contain alcohol.
No, bhang does not. It contains some narcotic substance. It's a non-alcohol, it's non-alcoholic intoxicant.
It's not liquor.
Not liquor, it's not liquor.
Lord, bhang is a separate item even for excise.
Yes.
It is
Not a liquor.
Yes, yes, it is uncontrolled. Bhang is the worst intoxicant.
Lordship goes to Konkan also to take the coconut tree study which we get.
I was just going to ask Tadi, Neera.
Neera, yes. After evening, Neera becomes.
Study. These are what's called self-generating alcohol. In Kashayams and all in Ayurvedic medicines, alcohol itself by internal fermentation is generated.
So for instance, in Kerala, if you go to Kerala or even Goa, in the evening, there's somebody will come to the coconut palm, climb up in a moment and get you the toddy. You have it. It's very extremely pungent, but it's not alcoholic.
No,
You
it
keep it in the morning,
becomes
it
by the
becomes
evening.
alcohol.
Keep it for the day.
It becomes alcohol.
It becomes after in the evening.
Pulled down from the tree, it's tapped from the tree, it's not alcoholic.
No, it's
You
not.
may still not be able to have it because it has a very distinct odor.
As the
But
day
it's
goes
not
by,
alcoholic at all.
No,
As the
therefore,
day
the
goes by,
toddy shops
fermentation makes it
fermentation takes place, then it becomes alcoholic.
yes, toddy shops are closed after afternoon.
So many times
Because
on the
it
highways in
starts
Maharashtra,
getting
you will
fermented.
find these little steel kiosks which say, Yete Neera Vikrila hai.
I was told Nira becomes Madi, then Madi becomes Tadi. That was what I was told in Konkan. No, even in UP, Lord, Nira is had in the morning.
He is right. He is right. Mr. Datar is right.
So even in our younger days, we used to go to the village. You get morning Nira, it's quite tasty and fresh. But even it's fermented, it becomes more and more.
So therefore, Gujarat being a prohibited state, all Neera shops are closed after 2 o'clock because then it start getting fermented.
Fermentation process starts.
So, but that is alcohol. It becomes alcohol.
It becomes alcohol.
Intoxicating.
Lord, now, Lord, I may show some history.
They will not permit you to carry. Even we have it today.
Toddy or Nira seems to be a little intoxicating. It's not so deeply engrossed in the discussion of Nira.
We were discussing how toddy is added to appam to make it fluffy.
But toddy, my friend said during my young days we used to have it. Not, I think that is wrong. Toddy even had today, Lord, is delicious. I mean, sorry, maybe Nira.
Nira.
It's
In the morning,
delicious.
yes.
Yeah, it's delicious. And it's healthy. They say it's healthy.
Delicious is a subjective thing, but yes, it is healthy. No, sir. It's pungent. But
No, Nira is not.
Nira is not.
What Mr.
Nira is
Dwivedi
like
saying
an
that,
earlier, coconut.
what Mr. Dwivedi is saying that even Solicitor General can have Nira. You see.
Yes.
Yes.
Is not toddy.
Toddy is pungent.
Toddy is.
But he talks of alcohol.
Yes, Nira is not
elsewhere.
toddy.
My friend talks of alcohol. He recites couplets also about alcohol flowing from the eyes, perhaps.
Well, para 42, well, kindly see, well, one of this argument.
The only point which they have been trying to make is that the word intoxicating per se does not exclude intoxicating liquor which is not for human consumption. That's their case. So
That is para 42. I wanted
Para
your
42.
lordships- Yes, Lord. Because it should be consumable. You cannot make it drinkable. It has to be a beverage.
para 42.
42, my lord, at page 34. Secondly, the term intoxicating liquor would necessarily mean a product which can be taken as it is, by which one gets the effect of intoxication. It may be possible that some form of industrial alcohol, that is non-potable, may bring the effect of intoxicant if diluted or mixed with some other chemical or taken in a particular manner. Entry 8 list 2, however, consciously covers the field for a product which is capable of being consumed as it is for bringing the effect of intoxication, and not something which is not an intoxicating beverage but has the potential of being converted into an intoxicating thing. But you can't go into the market and say that give me denatured spirit or give me ANA and then mix it with something or dilute it with something. It has to be consumable as it is, as a beverage, which gives the effect of intoxication to a human being. Otherwise, my lord, there is impossible to reconcile this, my lord. That center has non-potable, state has potable.
Our mind gets in.
But 43 also. For para 43 at page 35 also, my lord, I have given the distinction that something can be used, something can be abused. Please see, my lord. It is submitted that as far as possible, a common parlance understanding and meaning shall have to be given to the expressions used in the Constitution. The common parlance understanding of the expression intoxicating liquor is an intoxicating beverage containing liquor and having the effect of intoxication, and merely because some other form of alcohol, that is, industrial alcohol, etc., can be abused for getting intoxicated after making some changes in the composition, would never be falling within the meaning of entry 8 list 2. And there is a reason, my lords. There is a reason. Lord, entry 8 is a regulatory entry. Suppose we read in intoxicating liquor, even non-potable alcohol. Lord, would the state, I'm posing a question to myself, regulate that when you buy non-potable alcohol, namely ANA or any industrial alcohol, I hereby regulate, don't add more than 30% weight for volume water or add more than 50% volume per water. That's not regulation contemplated.
But there's only one area, Mr. Solicitor, one area, just consider it. Suppose there is some kind of, and there is now as we know, intoxicating liquor, sorry, industrial alcohol, or I can say denatured spirit. Industrial alcohol is an inappropriate phrase. Denatured spirit, which can, and we know that it can, be converted into intoxicating liquor, either by a process or by whatever. Now, if that possibility of abuse is there, can we deny to the state its regulatory power to ensure that the abuse does not take place? I'll tell you why. Center is, I mean, no, it's not pejorative. Center is a disconnected entity from the states. You're a national entity. You're not going to control, what's happening in every district, in every collectorate. Suppose there is a strong possibility of denatured spirit being misused for the purpose of consumption. State is vitally concerned as the custodian of public health. I don't want this liquor tragedy to take place within my jurisdiction. So state can impose regulations for ensuring that abuse does not take place. If we concede to that state the power to regulate for the limited purpose, even assuming you are right, that entry 8 covers only intoxicating liquor and liquor which is therefore intoxicating for human consumption. The state is still keen on ensuring that somebody else does not use a product which may be of grave danger to public health by misusing the nature of the product. They can make regulations limited for that purpose. And as an incident of making regulations for that purpose, why should we deny them the power to impose fees for that purpose?
Not fees, my lord. The regulatory power, my lord, would be not to consume that, my lord. And
Not to consume it, or for instance, you must, if you are transporting denatured spirit, that you must have whatever passes, licenses, or that you will transport it under certain conditions, declaration in a certain form, variety of regulatory programs.
that can be done by the center. I'll show, my lord, from IDRA. That is what is contemplated. For so far as
Can the state not also say, look, this is happening within my territory, this is likely to affect, and we now know that these tragedies, tragedies and all these tragedies
which is different, my lord.
No, I'm just giving you an example that these tragedies do take place. The states are vitally concerned with the health of their citizens. Now, why should the state not have the power to just regulate? And if they can regulate to ensure that there is no misuse, then you can impose any fees as an incident of your power to regulate.
Health is a separate entry 26, entry 6 in the third list, in list 3, in the second list. But maybe in that exercise of that power they can.
Exactly.
But so far as the industrial alcohol, non-potable is concerned, the regulation under the IRDA will have to be made by the center. Maybe delegating the exercise of powers to the state. That these are the statutory regulations. Every company manufacturing denatured alcohol will have to get this much these many registers. It will have to make entries. It will have to sell it only to authorized dealers. It will have to ensure that it doesn't go to unauthorized hands. Your police officials will ensure that it is not being used for the purpose of converting clandestinely into something which gives intoxication, etc., etc. But the law will have to be, in my submission, traced under Malot 52, because it is non-potable alcohol. It will not fall within 8. And Malot, this is how the drink is treated. Intoxicating liquor is treated historically, and that in a short while, I'll just give, if your lordships can come to page 35.
No,
How, my lord?
Solicitor, it was argued that denatured spirit can be converted into something which can be consumed. It becomes intoxicating liquor. So, state has power to legislate for regulating something which is prepared by using denatured spirit. Suppose denatured spirit is converted by some process into intoxicating liquor. That aspect can be also regulated by the state government.
I'm sorry, my lord, the argument is fallacious.
So
Denatured.
firstly, tell us whether it is possible to convert denatured spirit into a intoxicating liquor.
That argument I am respectfully submitting is fallacious for the reason, denatured alcohol without any industrial process by some clandestine process can never be converted into a consumable product. It is converted into a product which gives you intoxication. But for example, snake bites in a limited quantity gives you intoxication. Some cough syrups have alcohol content, more alcohol content. People drink the entire bottle and get the intoxication. This is an intoxicating drink, but not permitted. When you convert in clandestinely, what they do in the breweries, they convert industrial alcohol into potable alcohol, but by way of methodology, by way of machines, by way of controlled environment, by way of a particular temperature being maintained, etc. And the purpose is to create alcohol, the beverage for human consumption. What we are discussing and what my learned friend was giving an example, it is capable of being converted, meaning thereby we can add something and we'll get intoxicated. But that is not intoxicating liquor. You are clandestinely misusing the product with a view to ensure that you get
It's
intoxicated.
a regulatory entry, structuring the regulatory power of the state. So when entry 8 says intoxicating liquor, it would be very restrictive for us to say that this will apply only to properly so-called intoxicating liquor. Why cannot it extend to regulating those products which are misused for the purpose of selling them off as intoxicating liquor? Because, because then what we'll be doing is we'll be telling the states that, look, you can't do anything, even though there's a grave danger that this would be used for the
They can
purpose
do
of,
many things, I'll show.
but under the central law, you are saying.
No. Even under the state law. Bro, please see, my lord, how this history has developed. How United Nations used to and still controls the word intoxicating liquor. My lord, we have derived the imprints of this expression from United States.
Therefore, you concede
United.
you concede, therefore you accept, not concede, you accept that the states do have the limited power, whatever that powers we'll see, to regulate.
For health. If Hooch is different. Hooch is completely different, my lord. It's kind of a unauthorized small brewery. What my learned friend is talking about is that I buy denatured spirit, adds water into it, and if I drink.
Constitution. I have, yeah. Yes. So,
I buy the.
You talked about clandestinely made intoxicating liquor. So if it is a clandestinely made intoxicating liquor, it will be entry 8.
No, my lord, it would be health, law and order, etc.
Because
Intoxicating liquor means pure and simple beverage manufactured, commonly used for the purpose of serving to people. We will have to give that meaning. Otherwise, there may be several.
but it will also cover those liquors which are passed off as intoxicating liquors, because they have a deleterious effect.
They can't cover
Entry 6
exceptions.
and entry 8 of list 2 are not in that sense disjunctive entries. They are both, the state has both powers under the domain under entry 6 and the domain under entry 8. Entry 6 says public health, entry 8 says intoxicating liquor. Why can't the state say that, well, we are concerned about the fact that there are products in the nature of denatured spirit which are being passed off as intoxicating liquor, and we want to prevent that happening by having regulatory measures in place
Then
limited to that purpose.
one way of interpreting is
entry 6, my lord, entry 6, even law and order. Even law and order. The reason I'll tell you, Lord.
But once we accept that the states can do it, whether it's under entry 6 or entry 8, it makes no difference.
No, but I am protecting 52.
Incidentally entry 6.
It is entry 6 only.
But I am protecting 52. Sum total would be my lord, sum total, I'm sorry. I'm going to say that. Share your lordship's concern that so far as the effect of an abuse is concerned, the state would be more concerned in regulating that. Lord, let kindly examine, my lord, from another angle. What would be the constitutional position, my lord, if that view is taken? That's my respectful submission. My lord, one thing is clear, if I am right, that non-potable liquor, the regulation is with the center. Potable liquor, regulation is with the state. That's the constitutional position. Now, your lordships, by a judicial verdict, create a third category that any abuse of non-potable liquor as potable liquor will go to the state, which would amount to amending the entry.
Take a case of, say, the state of Gujarat or the state of Bihar.
Yes,
They have imposed prohibition. They have a policy of prohibition.
yes, ma'am.
No liquor consumption, no consumption of liquor or alcohol for potable purposes.
Yes, ma'am.
That is completely, therefore, outlawed within the state. If we accept your very rigid classification, that would mean that much as though these two states have imposed a policy of prohibition, you cannot control the inflow of this clandestine trade in, say, denatured spirit or liquor or industrial alcohol, which is capable of being and is being used for the purposes of
That is, my lord, a practical way of looking at it. But, my lord, kindly see, where do we stop? If that is so, the state can, if that is right, then the state can legitimately say that non-potable alcohol which is manufactured in Gujarat or Bihar, also we will control that it has to have a particular degree of alcohol so that it is not abused. Then they start regulating the manufacture also. How do we define the abuse? Because maybe at some percentage of alcohol, of in the denatured alcohol, it is either easily possible to abuse or it is difficult to abuse. Then, my lord, they can say that for the purpose of ensuring that my prohibition law is not flouted by clandestine means, I will issue a direction to the breweries that this is how you will exercise the power, exercise the manufacturing process of bringing denatured alcohol. Lord, therefore, Lord, even for the purpose of, my lord, a very right concern expressed by your lordships, the solution is a directive by the center under the IDRA that this is how you will have to control. Because this is not a problem, my lord, only in the prohibited state. I mean, states having prohibition.
No, everywhere.
This is everywhere because of financial reasons.
Except in the prohibition states, the stakes are much higher because you can't get it lawfully.
Yes, yes. My lord, there are
For the more
certain-
stricter the regulation, the more the people want to evade, right?
Yes.
That's why in the prohibition states, there's a premium for people who want to evade. And they extract that premium. It's a hard
Lord,
fact.
there are certain things, my lord, for example, even where there is no prohibition. Now people are fed up. We have studied something with the regular kick which the alcohol gives. For some states, my lord, I can't name the states, it doesn't look good. People consume, my lord, very regularly 1 or 2 bottles of cough syrup. Because that's they say it's a different kind of a kick. Your lordships would be amazed. Iodex, which is used, my lord, for the purpose of some pain, etc. Iodex. They not only smell, they put it on a jam like put it on a bread like jam, and they eat.
In fact, usually these NDPS bail applications, the recovery of 3,000 bottles of cough syrup. Codeine. 3,000 bottles of cough syrup.
Lord, for example, white ink, the eraser ink. So eraser ink, my lord, is a product, my lord, where we used to use it, my lord, when you used to have a manual typewriter. That is being used for intoxication, my lord. Then, my lord, though eraser ink may not be within the state subject, which have you to ensure that it is not misused, the state can, my lord, on that very logic regulate even eraser ink. That white ink, my lord, your lordship, all of us, my lord, have used it before. These people may not have known, my lord.
Erasex.
Yes.
That product is called, that
Yes.
whitener.
That's the correct one, no?
There are
Whitener.
those ballpoints also where you just
Yes.
press it and then it comes out.
Yes, sir, that was
Earlier
also.
you had those brushes,
Yes.
Yes.
small brushes.
Stencil,
That's right.
See, that is not an intoxicating liquor at any rate. It is an industrial product.
No, I am saying something else. Say, for example, hypothetically, this whitener or white ink is controlled otherwise by the center under some entry, but with a view to avoid its abuse, it can be controlled by the state also if this argument is, if this interpretation is right.
Under entry 6 of list 2, health purpose.
But no, I am saying under 52 they cannot do it. But if there is any other power, of course, my lord, nobody can take away except, my lord, by amending the constitution. The entry, my lord, my respectful submission is your lordships would go by the generic sense of the word rather than abuse, my lord. If we go by each entry, its abuse may find place, my lord, in some other entry as well, in some other list as well. And, my lord, I will show when I come to the scheme, my learned friends have already shown 18G of the IDRA. There are power to issue directions that you do this, you do that, etc., etc. And my lord, maybe regulations can be framed for that purpose. That's the answer. My lord. Conferring power and tracing it under entry 8 may perhaps not be the correct position. My lord, now kindly come to page 36. My lord, we have borrowed this expression from British legislations.
But my only submission is my friend arguing that synthetics is wrong?
Entry 8.
Synthetic says the power is there to regulate industrial alcohol.
But we are on the I'll respond, my lord, when
Paragraph
36, my lord, page 36. There is a chart, my lord. My lord, we have borrowed some of the expressions from the British legislations. How British used to, because this has come from 1919 and 1935, at least during the British regime. So we can safely rely upon what they used to consider intoxicating liquor. And I'll show, my lord, the statement of objects and reasons of this act, the Licensing Act.
Before we read this, your submission is that intoxicating liquor means something which can be consumed
As it is as a beverage.
by a human being. And if there is an abuse, there are other powers, other entities which can take care of that. That's what some
Cannot be, in my submission, cannot be traced to entry 8.
There are other entities
Because it
which can
is
take-
potable alcohol and yes. Lord, UK Parliament enacted the Licensing Act
Many of
18.
these acts which you have brought into the chart are also those covered in Balsara? Are they some of these also, because we'll have to deal with Balsara. You'll have to answer Balsara. Many of these I think are in Balsara also, right?
No, no, my lord. Balsara has not analyzed these acts. My lord.
It has not analyzed it.
It has not analyzed.
I thought some of these are also the ones which
No, my
Balsara.
lord, but Balsara mentions this, but they have no, Balsara doesn't analyze it. And I would wish to
So
show.
they find mention in the judgment. They
Yes,
find
yes,
mention.
yes,
in
yes.
it. That's what I was asking.
Yes, but please, my lord, see page 36, intoxicating liquor, and I'll request your lordships to read, which is not, my lord, taken note of by Balsara. The definition of intoxicating liquor means spirits, wine, beer, porter, cider, perry, and sweets, and any fermented, distilled, or spirituous liquor which cannot, according to any law for the time being in force, be legally sold without a license from the Commissioner of Inland Revenue. Now, please come to, my lord, page 578, volume 4B. Lord, preamble of this act. Lord, this is not taken note of by Balsara, my lord. The lordship gets, my lord. Volume 4B, page 578. An act for regulating the sale of intoxicating liquors. Lord, the same expression we have borrowed. Please see. Where does your lordships get, my lord, Justice Sinha? Whereas it is expedient to amend the law for the sale by retail of intoxicating liquors and the regulation of public houses and other places in which intoxicating liquors are sold, and to make,
Okay, 578.
I'm sorry, my lord, page
578.
578.
Yes, I got it. Yes. Yes, what were you reading?
Lord,
Where is
I'm
which?
reading the
The
preamble of an act for regulating sale of intoxicating liquor. It is Licensing Act 1872. So intoxicating liquor is the expression, my lord, we have used in our constitution. Lord, volume 4B. My lord, Justice, my lord.
No, it says it is not applicable to Scotland.
Maybe, my lord, I'm told there are separate acts, my lord.
No, most of the scotches are from
Scotch
Scotland.
is from-
Scotch is made, yes, my lord. The Scotch is made in Scotland. whereas it is expedient to amend the law for the sale by retail of intoxicating liquors and the regulation of public houses and other places in which intoxicating liquors are sold, and to make further provision in respect of the grant of new licenses for the sale of intoxicating liquor and better prevention of drunkenness. A human being is necessary. And intoxicating liquor, my lord, please see section 3. No person shall sell or expose for sale by retail any intoxicating liquor without being duly licensed to sell the same, or at any place where he is not authorized by his license to sell the same. Any person selling or exposing for sale by retail any intoxicating liquor which he is not licensed to sell, etc., etc. Please see about section 5 also at page 579. Your Lordship gets one at the foot of
Yes.
page 579.
Yes.
Look, the marginal note is seller liable for drinking on premises contrary to license. If any purchaser of any intoxicating liquor from a person who is not licensed to sell the same be drunk, that human element of, my lord, getting intoxicated on the premises, drink such liquor on the premises where the same is sold, or any other highway adjoining or near such premises, the seller or such liquor shall, if it appears that such drinking was with the privity or consent, etc., etc. But similarly, see, 6. Drunkenness is the subject matter, my lord. This is the regulation which the state can make. 6. If any person having a license to sell intoxicating liquor not to be drunk on the premises himself takes or carries or employs or suffers any other person to take or carry any intoxicating liquor out of or from the premises of such licensed person for the purpose of being sold on his account, so and so, so and so, so and so. Kindly see last 3 lines. The purchaser thereof on the premises of such licensed person with his privity and consent, and such licensed person shall be punished accordingly in manner provided by this act. This is the regulation which the state can make. Similarly, 8. Every person shall sell all intoxicating liquor which is sold by retail and not in cask or bottle, and is not sold in a quantity less than half a pint, etc., etc. This can be, my lord, then offences and penalties at 582. My lord, I am not
The meaning of the expression sober as a judge?
Not sober as a judge, but from the point of view of the bar, has nothing to do with alcohol.
That's a good one.
The question is which part? Which part?
Main expert who is going to argue now in your side, following your argument.
On alcohol?
I didn't say that, I just said domain expert.
I can come back after, my lord. Your lordship knows about the story of Shankaracharya. But I'll just take 2 minutes. Shankaracharya used to do Shastrarth, which is a debate with everyone. So he went to a very great scholar and a very elderly rishi. Shankaracharya was very young, obviously. It's called
Mandana Mishra.
Mandana Mishra. And Mandana Mishra said that you are young, I am very old, so I'll give you one advantage. You choose the judge who will decide who won. Shankaracharya says that your wife, who is also equally learned, will be the judge. And the debate started. The wife started realizing that my husband is losing. So at some stage, almost at the end, she said that I am the wife of the contestant and I am Ardhangini. So I am also supposed to ask you certain questions. I'm entitled to ask you questions. She said, technically you are right, you can ask me questions. Then she started asking questions about sex because he was a celibate. So Shankaracharya was taken aback. He said, then give me some time. Then he, the Parkaya, Pravesh, etc., it's believed, he learned about it and thereafter answered it, my lord. I can answer, my lord, after this long weekend. After becoming a domain expert. But ultimately, my lord.
They were telling us some of us are with him.
But, my lord, she declared Shankaracharya to be the winner. The wife eventually declared Shankaracharya.
The final question sealed the victory.
Yes.
Final question.
Yes. Lord, now please see, my lord, page, and none of these is considered in Balsara, my lord. They note the act.
You won that.
632, same volume, my lord. Yes, my lord. Page 4B. Lord, this is House of Commons debate. This is not taken note of by Balsara. I am just showing, my lord, how Britain used to conceptualize or consider or define the term intoxicating liquor. Lord, Mr. Herbert Roberts, your lordship gets, my lord. Because we have the imprints of this law, my lord, let us face it. The expressions are, my lord, the same. Your lordship gets, my lord, the Chief Justice gets one.
Yes.
Mr. Herbert.
This is pertaining to intoxicating liquor and drugs in India, although the
Yes,
debate is in
British India. Yes. I beg to ask the Secretary of State for India whether he is aware of the number of shops open for the sale of intoxicating liquor and drugs in India rose from so-and-so to so-and-so, that the net revenue on liquor and drugs consumed in India for the year so-and-so, an increase of so-and-so, so-and-so, and last, shops opened and consequent increase in consumption. Then the Secretary of State for India, Mr. Bodrick, answers, the increase in the number of shops was considerable only in the two provinces of Bengal and central provinces. In Bengal, it was chiefly due to the fact that many shops sanctioned but unlet in 1902 were let in 2003, and in the central provinces to the government taking over the excise arrangements in certain semi-fiduciary areas and to the consequent more strict enforcement of the law. As the increase of revenue in 1982 to 3 over 1901 to 2 in these two provinces was not marked, the additional shops could not have had much effect on consumption. But they also use it in the sense of consumption in shops. But how we regulate? How would the state regulate potable liquor? They will give license that only licensed person can sell. The licensed person will have this much capacity. The licensed person will have to make certain arrangement for securities. The licensed person will have to ensure that it is not sold or consumed in public places. That is the regulation contemplated under entry 8. If somebody abuses it, so that is not within the domain of the state. So similar, I'm not duplicating 634. It further goes, hours of sale of intoxicating liquors, page 634. Herbert Roberts asked the Under Secretary of State of India whether he is aware that Government of India have expressed an opinion in favor of curtailing the hours of sale of intoxicating liquors. Sale of intoxicating liquors as beverages, that is how it has always been understood. Whether he has seen the statement, etc., then I'm not duplicating. But please see the answer. The next, Herbert Roberts asked the Under Secretary for India whether he is aware of the almost unanimous consensus of opinion amongst district officers in Bombay that the change from the unrestricted auctioning of license has resulted in a noticeable improvement in the management of liquor traffic, whether since the introduction of the fixed fee system in Bombay, there has been a substantial diminution of the consumption of intoxicating liquor, etc. But intoxicating liquor has, this is only to show, intoxicating liquor has always been understood as meaning something which is sold as a beverage, which has an impact on impact of intoxication on human beings under licensed premises or under a valid license. And when we say human consumption, we necessarily say human legitimate consumption. Last act at page 37, I am not reading it. Intoxicating liquor sale to persons under 18 Bill 1923.
Page 630.
37. There are two acts, my lord. I'm sorry, one act which remains. Last, my lord, in the chart. Intoxicating liquor within brackets sale to persons under 18 Bill 1923. Your Lordships can just note page 636 of the same volume, but it is using the expression in the same term. So my respectful submission is, Your Lordships would consider using this, giving interpretation to this expression the way it has always been understood. Lord, for example, snake bite is the latest form of kick in some cases. Lord, suppose it is capable of being converted into a drink. It would be intoxicating. It may have some amount of liquor, we do not know. So would it be treated as an intoxicating liquor? Well, the answer is no. It is alcohol-based drink which is served as a beverage for human beings, having the effect of intoxication, which is popularly consumed. Now, my lord, I would wish, my lord, your lordships to have what is alcohol and its forms, my lord. So that is at page. I'll come to Balsara a little later when I take judgments, my lord. All the judgments I'll take simultaneously, and then I'll show the scheme of IDRA, my lord. Page 50, if your lordships can see, my lord. This is, my lord, sitting with the officials, my lord, we have prepared this. that what is the type of alcohol? Your lordships were taken through them, my lord. There is some deviation. Your lordships would like me to skip this one.
Well, you are on discussing something else. I think.
Please.
Well, which para?
My lord, I am on page 51, para 60.
In the same volume,
Yeah. Same, so written submissions, my lord. 2D. Lord, I am on para 60, page 51. Rather, my lord, if your lordships can go a little back, my lord, para 58. That may give a little holistic picture, my lord. And then I'll show, my lord, the scheme of the Industrial Dispute Act to demolish that this very fundamental argument that 18G is the only provision is absolutely fallacious. The Act occupies the entire field. But para 58, your lordship gets one. My lord, the Chief Justice gets one. Para 50. The term alcohol means ethyl alcohol and any strength and purity having chemical composition C2H50H, OH, sorry. Ethyl alcohol, which is non-potable, is a very vital and widely used raw material in several industries such as pharmaceutical and drugs, rubber, petroleum, etc. It is used as an anti-freeze material in automobile radiator. It is also used as antiseptic. It is also used in preparation of ether, chloroform, iodoform, so and so. It is also used in manufacture of drugs, perfumes, etc. Ethyl alcohol is used as an industrial solvent for paints, lacquers, dyes, varnishes, cosmetics, etc. So far as alcohol is concerned, the following details are relevant. Alcohol is derived through a distillation process where carbohydrate, sugar or starch is fermented and then distilled to extract alcohol. Alcohol can be made from any feedstock which has high content of carbohydrates such as sugarcane, rice, maize, potato, beetroot, etc. In India, alcohol is predominantly made from sugarcane juice, molasses, a byproduct of sugar production, broken rice, and maize. Major types of alcohol are given below. Rectified spirit generated after distillation having minimum 95% of ethanol content is used only for industrial purpose. It is used for industrial purposes such as use as solvent in paints, industrial chemicals, etc. Then extra neutral alcohol. This neutral spirit having minimum 96% ethanol content is made by further purifying the RS, that is rectified spirit. This is used both for potable alcohol and industrial purposes. Then absolute alcohol, also known as absolute alcohol having minimum 99.6% ethanol content, is also an industrial alcohol and is produced by further removing the water from rectified spirit and used in pharma industry. Now, denatured alcohol refers to alcohol products adulterated with toxic and or bad tasting additives, that is methanol, benzene, pyridine, castor oil, gasoline, so and so, making it unsuitable for human consumption. Please mark this. Denatured alcohol is not fit for human consumption. It is used in fuel blending, making disinfectants, tinctures, varnishes, preserving biological specimens, industrial solvents, etc. Then, my lord, potable alcohol for human consumption can be categorized, that is India-made foreign liquor. Normal standard is at 42.8%, and country liquor varies from state to state, but between 25 to 35%. Please see, my lord, the chart which we have prepared, my lord, in consultation with the officers. My lord, first is molasses, sugar syrup or grains. Then this is the raw material. Please note this, my lord. This is the raw material for production of alcohol. Then adding water and enzymes for fermentation plus grinding in case of grains. That is the preparation. Third is fermentation. Time is taken up to 72 hours. Then distillation means removing of water and impurities to get pure alcohol. From where three things which we can obtain. One is rectified spirit, only used for industrial purposes in industries such as paint, chemicals, etc. That is minimum 95% of ethanol weight per volume. Then absolute alcohol is made upon dehydration, that is called industrial alcohol, used in pharma industry. And on the right hand side, your lordship would find upon further purification of rectified spirit or ENA, we get industrial use depending upon the market conditions. This is where regulation comes. Some industries go for only industrial alcohol, and some industries go for alcoholic beverages, that is scotch, whiskey, rum, gin, etc., etc. Now on the left hand side again, if ethyl alcohol undergoes the process of denaturation, we get denatured alcohol, which is toxic. The argument was denatured alcohol is fit for human consumption. I'll show it is toxic. It is not fit for human consumption. Toxic, unfit for human consumption, and used to mix in fuel, disinfectant, making tinctures, varnishes, preserving a biological specimen, etc. My lord. Now please see, Lord, there is one judgment, my lord, VAM Organics, which directly deals with denatured alcohol. Lord, one of this judgment, VAM Organics, my Lord Justice Oak had an occasion to deal with in Bombay High Court, sitting with Justice Chagla. It is authored by Justice Chagla, but your lordships have seen this, my lord. I'll just read page 54, para 61. At this stage, it is required to be pointed out that it is absolutely wrong to suggest that denatured alcohol is either potable or fit for human consumption. As a matter of fact, the additives are added in pure alcohol to make it poisonous, bad taste, foul smell, and to discourage its human consumption. In some countries, it is also dried so that it can be identified visually. Some dry, it should be dyed. Lordship, kindly allow me to, it should be DYED. It is used as a solvent and as a fuel for alcohol burner and camping stores, apart from having other industrial uses. This fact is judicially recognized by this honorable court in the judgment of VAM Organics. Lord, I'll just read this para. Before proceeding further, it will be proper to understand the difference between industrial alcohol, denatured spirit, and potable liquor. Ethyl alcohol is a rectified spirit of 95% weight per volume in strength. Rectified spirit is highly toxic and unfit for human consumption. However, rectified spirit diluted with water is country liquor. Rectified spirit, as it is, can be used for manufacture of various other products like chemicals, etc. Rectified spirit produced for industrial use is required by a notification issued under the Act to be demonstrated in order to prevent the spirit from being directed to human consumption. Rectified spirit is denatured by adding denaturants which make the spirit unpalatable and nauseating. As such, rectified spirit can be converted to potable liquor, but once denatured, it can be used only as an industrial alcohol. The process of denaturation described by the respondent is narrated by the High Court in the following terms. My lord, I can skip that. Eventually, my lord, it says that denatured alcohol is toxic. It is made toxic so that people don't consume it. In some countries, it is even dyed. Dye is added to it. So the argument that denatured spirit with some dilution can still be consumed is fallacious. My lord, I'll come to, my lord, the position of sugar, etc., my lord, a little later. Now let me take your lordships to the industrial development and regulation. Lord, I want, my Lord, some statistics to be shown that why this regulation is necessary. Lord, for example, during COVID, the maximum requirement was that of this Lord, sanitizer, alcohol-based sanitizer. The government did issue directions. They were under the Essential Commodities Act because it is stricter, but it can be issued even under the IDRA. They don't produce anything, don't produce the potable liquor right now, produce only industrial alcohol. Government issued directions, my Lord, Chief Justice is aware, in some other context, my lords have seen this. When we needed oxygen, all steel plants were closed down. That you will not manufacture, because every steel plant has oxygen generation stations. They generate industrial oxygen.
Which is far more purified than the regular.
But they were all directed not to generate any industrial oxygen, generate only medical oxygen. And medical oxygen used to be transported everywhere. But I'll show you those figures, why this regulation is necessary. Lord, kindly see, my Lord, ideal. Political issue. Volume 4, 547. Your Lordship, my Lord, I may be permitted to use for limited purpose, my Lord, the book. 547. The statute, my Lord, Industrial Development and Regulation Act. Lord, the purpose is to show, at the outset I may say, that 18G is not the only section. The Act as a whole occupies the field. And there is, my Lord, a manifest parliamentary intention to occupy the field. The Lordships may kindly see section 2. Lord, I take your Lordships to the history of this act a little later. First, let me show the act itself. Declaration as to expediency of control by the Union. It is hereby declared that it is expedient in the public interest that the Union should take under its control the industries specified in the first schedule. But this is a declaration contemplated under entry 52, list 1. Correct, madams? Now, please see, Lord, scheduled industry is as specified. Please see section 5. Establishment and constitution of Central Advisory Council and its functions. For the purpose of advising it on matters concerning development and regulation of scheduled industries, the central government may, by notified order, please mark this, notified order word is used at more than one places. I'll have to squarely meet with that argument. And I have an answer. Respectfully, my lord, I would try and persuade your lordships. Notified order, establish a council to be called the Central Advisory Council. The advisory council shall consist of a chairman so-and-so. Your lordships can skip, rest is not necessary. Section 6, my lord. Establishment and constitution of development council and their functions. Rest may not be relevant for your lordships, my lord. Please see subsection 4. Your lordship gets, my lord, subsection 4. A development council shall perform such functions of a kind specified in the second schedule as may be assigned to it by the central government, and for whose exercise by the development council it appears to the central government expedient to provide in order to increase the efficiency or productivity in the scheduled industry. Please mark this, my lord. The productivity comes, or group of scheduled industries for which the development council is established to improve or develop the service that such industry or group of industries renders or could render to the community, or to enable such industry or group of industries to render such service more amicably. But pausing here for a minute, please come to Schedule 2. Lord, your lordships would get it, my lord. I'll just show, my lord, some of the functions so that your lordships may not have to go through all the functions, my lord. These are the second schedule 6.4. Does your lordships get, my lord? Oh, it is at page 598, my lord. Same volume, 598. These are the functions of the council which will advise the central government, and central governments thereafter takes actions if required. Lord, 1, function number 1. I'll read, my lord, only those which are relevant for the present matter, my lord. Recommending targets for production, coordinating production programs, and reviewing progress from time to time. The production is a regulated activity. Then 2, suggesting norms of efficiency with a view to eliminating waste, obtaining maximum production, improving quality, and reducing cost. All this is regulated. 3, recommending measures for securing the fuller utilization of the installed capacity and for improving the working of the industry, particularly of the less efficient units. Promoting, then, my lord, 5, promoting standardization of products. The product is directly, my lord, controlled through the council. Then 7, my lord, promoting or undertaking inquiry as to materials and equipment and as to methods of production, management and labor utilization, including the discovery and development of new materials, equipment and methods of improvement in those already in use, the assessment of advantages of different alternatives, and the conduct of experimental establishments and of tests on a commercial scale. Lord, when we say promoting or undertaking inquiry as to the material and equipment for method of production, it necessarily includes raw material also. That you procure raw material in a particular fashion so that your maximum productivity and efficiency is improved. My lord, last 14, my lord, promoting the adoption of measures for increasing the productivity of labor, including measures for securing safer and better working conditions and provision and improvement of amenities and incentives for the workers. Lord, your Lordships may also see 10, my Lord, and 13, my Lords. I'm sorry, I missed that. Promoting or undertaking scientific and industrial research, research into matters affecting industrial psychology, and research into matters relating to production and to the consumption of use of goods and service supplied by the industry. Even consumption can be regulated. If the council advises, there can be a direction from the central government. This is how the consumption will be utilized. The consumption of non-potable alcohol. And my lord, 13, investigating possibilities of decentralizing stage and process of production with a view to encouraging the growth of allied small scale and cottage industries. It's a comprehensive regulatory mechanism. Lord, now coming back to the Act, my lord, please come to page, section 10, page 553, my lord. Section 10. So it's absolutely fallacious to say that 18G is the only section which is occupying the field. The entire Act, there is, my lord, a well thought of intention of the legislature, of the parliament, to occupy the field of regulation in whatever manner possible, right from sourcing the raw material till consumption. Your Lordships may come to its registration of existing industrial undertaking, but please come to subsection 3. Lord, I am not wasting your Lordships in time, my lord, for what is not relevant. Subsection 3. Where an industrial undertaking is registered under this section, there shall be issued to the owner of the undertaking or the central government, as the case may be, a certificate of registration. Now please see, containing the productive capacity of the industrial undertaking and such other particulars as may be prescribed. The production is regulated in the license itself. Then, my lord, 4. The owner of every industrial undertaking to whom a certificate of registration has been issued under this section before commencement of the Amendment Act shall, if the undertaking falls within such class of undertaking as the central government may, by notification in the official gazette, specify in this behalf, produce within such period as may be specified in such notification the certificate of registration for entering therein the productive capacity of the industrial undertaking and other prescribed particulars. If specifying the specifying the productive capacity in any certificate of registration issued under subsection 3, the central government shall take into consideration the productive or installed capacity of the industrial undertaking as specified in the application for registration made under subsection 1, the level of production immediately before the date on which the application for registration was made under subsection 1, the level of the highest annual production during the 3 years immediately preceding the introduction in Parliament, the so-and-so amendment bill, etc., etc. So production is very much a controlled item. Now, please come to 11.2. Now, this is licensing of new industrial undertaking. Subsection 2. A license 554, page 554. Your Lordship gets me. A license or permission under subsection 1 may contain such conditions, including, in particular, conditions as to the location of the undertaking and the minimum standards in respect of size to be provided therein, as the central government may deem fit to impose in accordance with rules, if any, made under section 30. Lord, the central government can even say that your location would be here because your raw material is here, and therefore the transport time would be less giving you more efficiency and more productivity. Then, my lord, 11A. The owner of an industrial undertaking not being the central government which is registered under section 10 or in respect of which a license of permission has been issued under 11 shall not produce.
More than what?
Very heartbroken.
I apologize, if I'm getting a little monotonous.
Section 11, right?
11.
11A we were on.
11A. So you will not produce or manufacture any new article unless, in the case of an industrial undertaking registered under section 10, he has obtained a license for producing or manufacturing such new article. If you want to produce new article, that production needs another.
What a draconian act, Mr. Solicitor.
Well, it's not under challenge.
I know, but
Correct, man.
completely an anachronism in
All
India today.
pervasive, all pervasive.
All pervasive.
My lord, I'm
Completely different economy, different regulatory regime.
my lord, that is going to be my answer when I answer the notified order.
You can't produce a new product until you have a license in respect of that product.
My purpose is not, my lord, I'm
No, no,
not,
we understand. We are not, there's no challenge to this act.
there is no challenge, my lord, but the
It's
purpose
just
is,
now saying, I mean, reading these provisions,
purpose is twofold. And I'll, my lord,
license Raj, absolutely. This was part of
like
the
it,
license
yes,
Raj.
it used to be called a
That
license.
was the concept that they had.
91, we have, the industrial policy 91 downwards, my lord, is diluting the license Raj. I'm not on that. The power is there, whether it is to be exercised or not, that depends upon the facts and circumstances.
Just
But
as
I'm
an
just
aside-
showing-
Just as an aside, I mean, it has nothing to do with this case. Has the coverage of the act been brought down by the central government by,
Yes, yes.
by deleting industries from the schedule? Or what?
No, not amending the schedule by, for example, there was potable, non-potable, it is now only non-potable, etc. my lord. But I'll point out, my lord, answering your lordship's question. And my lord, I'm not, my lord, answering it right now. I elaborate.
These sort of acts are they're designed to kill productivity, not really enhance productivity. Because I mean, imagine interesting to some bureaucrat somewhere in the ministry, if you want a new product, you have to be licensed to have the new product.
I fully agree with that. The purpose of pointing out is that productivity is a field occupied, number one. Number two, and I'll be very careful in answering this question. When we talk about regulation, so regulations are of two types. I'm going to develop it, my lord, with some assistance from other side. And kindly, my lord, listen to this very carefully, because this is my answer to notified order. Lord, whenever the act says notified order, by way of a notified order, it gives an enabling power to the central government to do or not to do. A regulatory power can be of two categories. A positive regulation, an active regulation. By doing something, you will not do it, take license, without license, don't do it. License also have conditions, etc. The second mode of regulation recognized throughout the world is regulation by forbearance. That right now I am not regulating, but that is the reason, that is the way I am regulating, by making a conscious choice of not regulating. But I have the power. Lord, suppose a situation arises like, Lord, COVID, then we can step in. Otherwise, my lord, this is an area which I will assist your lordship with, my lord, when we say notified order. Absence of a notified order is a regime of forbearance, that let the market forces play. Everything is going hunky-dory. There is no difficulty. We don't need to step in. But if the circumstances so exist, there is a statutory backing under which we can step in. But that conscious choice is regulation by forbearance. This is one of the concept which is developed throughout the world in all regulating bodies. So, my purpose of showing the provisions of the Act is to twofold, that there is occupying the field. The Act occupies the field. Good, bad, indifferent, constitutional, unconstitutional, etc. That's not the question right now. The Act occupies the field, but it is regulating by forbearance. When we say license Raj is given up, doesn't mean that this Act is repealed. The Act is not acted upon by a conscious economic policy call. But that is also a regulation. Therefore, you can regulate by not issuing a notified order.
What you were telling us just a while back, the switchover from potable alcohol to industrial alcohol, sanitizers and the industrial oxygen to medical oxygen, all that power or exercise under this 1951 Act.
Yes.
Notifications.
And suppose, well, even for non-potable alcohol, which is a scheduled product, scheduled industry, the central government can make a conscious choice that we will not regulate. We will regulate by forbearing to regulate. Let the market forces play its role. We will watch the market forces. And if everything is going on which is in national interest, maximum productivity, equitable distribution, etc., we will not step in. But we have the power to step in. So that is regulation by forbearance. So there is no notified order, meaning thereby we are regulating by exercising the regime of forbearance. And that's the new concept, Malad. That's a new concept worldwide in all regulatory bodies, that you retain the power and choose not to regulate. But that is also a choice. That is also a power of regulation.
As we read, and as we read along with you, we find that, so many nuances are there, and it's good that you're pointing it out, but it actually is capable of interfering in every facets of anybody doing anything.
That's my purpose of showing.
No, that
The
you are
purpose
showing.
is that it occupies the field.
But it is inconsistent with what the government is saying all along. I mean, I'm talking about not in the context of the challenge.
We are in a forbearance regime. But the Act occupies the field. That's the limited purpose of showing this. I am not showing that this is all I can do. I am saying this is all provided for. And therefore, there is a law which occupies the field, which is not under challenge on the ground of unconstitutionality. But right now, your lordships are examining whether, if the central law occupies the field, which is traceable to entry 52 list 1, and entry 33 list 2, then the state government's power is ousted. I am showing it occupies the field.
So you are saying, irrespective of whether there is a notified order or not under 18G, I have the power to issue a notified order, and therefore the states are outstripped by my creating that opportunity for myself.
The reason is, I will develop it, my lord. Since it fell from your lordships, this is a draconian, my lord. I just wanted to say that we are in a regime of forbearance. But I'll develop that, my lord. And it may sound a little, my lord, ambitious argument on this. But, my lord, world over, regulators are exercising regulatory power of regulation by forbearance.
Mr. Solicitor, not this kind of regulation. Regulators are exercising different kinds of regulatory powers, not like
Your
this.
lordships are,
Every time you want to set up an undertaking, you will license it, new product license.
your lordships are not examining Article 14. This is not 19(1)(g) or 14.
This whole statute is an anachronism in today's age. It's a complete anachronism.
Lord, your lordships are, my lord, I am with respect, my lord, repeating, Right now, the only thing which your lordships would see is whether by a good law or a bad law, the field by central legislature is occupied or not. Whether that law is valid or not is not the question.
But the law itself, that is section 18G says, if you want to regulate, you have to issue a notified order.
There are 4 or 5.
Notified order, you can regulate.
There are 4 or 5 places where notified or
No, where is the regulation?
And look at the kind of products it covers: cutlery, calculating
again, your
machines,
lordships are.
vacuum cleaners, sewing machines.
Lord, I'll show, my lord, that there are only 4 industries which are under regulation. Others are forbearance regime. That's the economic policy of the country, my lord. But your lordships are again, my lord, examining the validity from 14 and 19 1G point of view.
Economic policy therefore means, because obviously the government is on the one hand demonstrating that we are moving increasingly to market-driven economy.
Market-driven economy.
A market-driven economy, you attract investment, you want to
Correct,
create a
my lord.
business-friendly climate, and therefore there is forbearance from enforcing this,
Lord,
except in regard to 4 industries.
I'm sorry, my lord.
But therefore, we can't say that then there is the doctrine of occupied field. The government, it's a conscious decision not to implement the provisions of this act.
Yes, my lord. But I'll show that. I will show that, my lord. But right now, my lord, again, your lordships are persuaded, your lordships have persuaded yourself, my lord, to go into Article 14 and 19 1G arguments, which not, my lord, right now my purpose. My purpose is good, bad or indifferent. There is a provision which occupies the field and we have chosen not to implement that so far. Maybe, my lord, suppose, my lord, there is a defense industry. My lord, defense industry is one of the exceptions in Article 24, list 2, because of.
So, which are the 4 industries in relation to which the act is now
I'll show,
actually
I'll show
enforced by the government?
I'll show that. Well, let me complete the scheme of that.
It's about 5 to 4. We have to go for Justice Bose's
I know.
the farewell.
Can I
decision.
start, my lord, on the next?
We were on. We had come up to section 11A.
11. But, my lord, please do not examine it from the point of view of constitutionality.
And Mr. Solicitor, now how much time will you take?
My lord, your lordships would, my lord, agree that I have never repeated anything.
No, not at all. Just
And-
no, absolutely. We're not trying to tell you that you have, but
Lord, I think, my lord, 1 session and 1 hour, my lord.
if Mr. Solicitor, if you can wrap it up in one session,
My lord, the difficulty.
so we can give 1 hour to the people who are following you.
Lord.
After you, who's going to argue?
I'll definitely, my lord, make an attempt, but your lordships would, my lord, not mind my saying this. Lord, Tikaramji doesn't consider any of these.
That point you will make. Absolutely, you've made. No, we're not saying that you are.
In one brush, one line, it says that it's only for manufacture.
Mr. Solicitor, we're not rushing you at all. Just if
No,
you-
I'll, my lord, try
you
to
can-
be as precise.
If you can wrap it up by the first session on Tuesday, then the others can wrap it up, say by 3 o'clock.
Wednesday, my lord, possibly Tuesday, your lordships knows, my lord, maybe a miscellaneous day, my lord.
No, Tuesday is no.
No.
Wednesday is a holiday. Wednesday is a holiday. So we have Tuesday and Thursday.
Lord, I have no difficulty, my lord. I thought because Tuesday, Monday is a holiday. Monday is not a holiday.
You were thinking about the long weekend, taking the Monday into account
Yes.
for educating.
My lord, the child in me has not died, my lord, so far, that the school is closed, my lord, that I get the same thrill.
But you wanted to educate yourself on certain passages.
You have to be.
become in.
You have to be in some good company over the weekend. Mr. Solicitor.
Yes, my lord. Yes.
If you can't look.
Yes, sir, it has.
If for reasons of professional ethics, you can't look to your right, you can look to your left. You'll find some good company on this side as well.
Yes, my lord.
So Tuesday we'll come.
Tuesday, obliged to lodge.
16, there are 2 directions, some constitution benches for directions that, but it won't take more than 5 minutes each.
The 902, my lord,
Light motor vehicles and that arbitration.
obliged to.